Welcome to the Capital Forum's 7th Annual Antitrust Thought Leaders video series. My name's Anne McGregor and I'm the Brussels Bureau Chief for Capital Forum. I'm joined today by Creighton Macy, an antitrust partner at Baker McKenzie in Washington, D.C. Thanks for joining us, Creighton.
Thanks for having me. It's great to be here. Appreciate it.
And I just wanted to sort of recap your so far very distinguished, although not very long career.
Thank you.
So that we can perhaps get into what we want to talk about, which is largely your experience at the DOJ and how that compares with being in private practice. Yep. You first started your career in 2008 as a trial attorney in the DOJ's antitrust division. Yep. Then you were in private practice for about 6 years. You then had a little under a year back in the DOJ, but in a more political role as Chief of Staff for Renata Hess when she was the acting Assistant Attorney General of the division in the DOJ. And then, of course, when the Trump administration came in, you went back into private practice, and for about the last 2 years you've been at Baker's.
Yes.
So, you know, you've seen DOJ from a couple of different angles. You've also had some experience as a relatively junior attorney in practice, and then now as a more senior attorney in practice. What are some of the sort of nuggets that have come home to you, nuggets of, if you like, wisdom that have come home to you as a result of the career path you've had?
Sure. Well, thank you. And, you know, it's interesting to think back on it and think about it. But I've been tremendously fortunate to have so many different experiences, and frankly, 4 different experiences at this point that I've each liked very much and that are distinct and that expose me to a lot of different types of antitrust law, but also to a lot of different people that practice antitrust law, both in the government as a trial attorney, both in the government in the front office of the antitrust division, and in private practice now at 2 different places, all usually doing the same type of work, whether that's in DOJ as a trial attorney investigating merger transactions or civil conduct matters, whether it's in private practice representing companies before the DOJ or the FTC or on a global level. And, you know, I think that it's all what I've really learned in terms of what I do and what through the experiences that I have, it comes down to really digging into the case, digging into the facts so that you can represent your company or represent the investigation, you know, when you're at the DOJ as best you can. You know, I think that's what actually drew me to antitrust, and maybe I'm not sure I could have done anything else in the legal field, is that it's incredibly fact-specific, and you have this incredible opportunity to learn as much as you can about different companies, about different industries, about different segments, and then you apply the precedent, or then you apply the different law and things along those lines. So that's what I've learned as a very young attorney, then going to the DOJ, and then in private practice, and now more as a senior attorney after that, and seeing it at all levels, is that it's really about the specific matter at hand, digging in and learning it so you can advocate on behalf of your client, or then as a trial attorney at DOJ, you can advocate to your section management and the front office as to why a case should be closed, why you might want to bring a case and have a settlement, or why you might want to challenge a merger.
Right. So let's compare and contrast the 2 DOJ roles. As a trial attorney, you're sort of bottom of the food chain almost. Yeah. And then when you're Chief of Staff to the acting Assistant Attorney General, you're advising him or her on what should happen. You know, obviously there's a lot to be said for having, you know, done some grunt work at the beginning of your career and understanding how that works at that level. Right. But how do you think that experience then made you a better Chief of Staff?
Yeah, that's a great question, and I think of it kind of as the trial attorneys and the section management at the DOJ or the FTC are the engine. And if you will, there's 7 to 10 political folks that are in or out of the DOJ, depending on political party, each 4 years or each 8 years. But the high majority stays, and that's senior career people in the civil side, on the criminal side, the section managers and the trial attorneys who are there day-to-day, building cases, reviewing facts, speaking to many people, doing interviews, taking depositions, things along those lines. So it was a tremendous experience starting as a trial attorney, and those are the folks that are working up the cases and taking the cases to trial and actually trying them. And so the difference of there, I think I would describe it though, compared to the chief of staff role, where you're seeing things more of a 40,000 foot view compared to a 0 to 10,000 foot view. And that's my, before being in the front office as Renata's chief of staff and senior counsel, I was used to being, as I think most antitrust attorneys are, and you need to be, at the 0 to 10,000 foot view, learning the case facts, learning all of those things.
Into the detail.
Into the detail. And when you're the chief of staff, I think a significant luxury is you get to kind of see things at a very high level. And you're advising someone who's a principal, and everything funnels up to that person. And I was very fortunate to advise an incredible antitrust attorney and an incredible AAG and Renata Hesse, and before her was Bill Baer. And so my role as the chief of staff was really helping that funnel be as efficient as possible, being able to answer questions in terms of whether it's a substantive matter, whether it's an operations procedural matter, or whether it's something in terms of the associate attorney general or the deputy attorney general or the attorney general. They're kind of folks that have the antitrust portfolio in their office. So it's I think that it helped me tremendously, and it's really because I think the chief of staff role, not like any other position, not unlike any other position, is it's very people-based.
Right.
And so I had started at the antitrust division, and so when I came back, many of the folks that I worked with, who I respected tremendously and who were terrific attorneys, were now in management, whether we had worked on a case and I was a junior attorney and they were a mid-level attorney at the time. And I was very lucky in respect to when I started at the DOJ, there were some big cases that I worked on. One we challenged in involving a beef transaction, other one in the entertainment industry, which was a big settlement. And so I had this background of getting to know a lot of people. And I think that really helped me when I came back, because a lot of these folks who were either still trial attorneys or leading cases were in section management, were in the front office in various civil or criminal positions. And so it helped me because a lot of that role is part of is just talking with folks, and again helping the flow and helping the efficiency go straight up to the assistant attorney general so that he or she can best make the decision as the ultimate decision maker.
Right, right.
And as a side note, I mean, as you can probably already tell, I've been very lucky to have really love my colleagues in private practice, but at the division I met so many incredible people that some of them weren't there, but a lot of them were still there. And so from a personal level, just keep getting to go back and working with these people again, even though it was a little less than a year, was I think helped me in my job, but also wonderful from a personal level.
I suppose we've heard a lot in the last couple of years about the AT&T Time Warner case, which the DOJ challenged.
Yeah.
Unsuccessfully in the first instance, and also in the Court of Appeals unsuccessfully. Where does that really leave us in terms of vertical mergers in the US?
Yeah, it's a great question. So, well, one thing I would say too, the first point is I think there's been a lot of discussion about AT&T Time Warner and the fact that DOJ lost that case. But I think what's important not to lose sight of that, and maybe your audience is interested in the fact that DOJ and FTC before that case over the last 4 or 8 years was tremendously successful. Now, in merger challenges, whether it's the insurance cases at DOJ, Aetna Humana, Anthem Cigna that were going on at the same time,
right.
$30+ billion transactions, whether it was the Office Depot Staples case. So the DOJ, now these are horizontal cases, but I wouldn't, the DOJ and the FTC are going to win some and they're going to lose some. It just happens that AT&T Time Warner was unique in the fact that it was a first vertical merger that was
right.
challenged for a long time, and the fact that it has incredibly high scrutiny for a number of different reasons. But it's important not to forget that the same folks that were trying the big insurance cases or the low-level radioactive waste, nuclear waste case that DOJ was victorious on are still there, and they're the same people that some of them tried the AT&T Time Warner
right.
case. Right. So I don't take from it that it's a lack of, that it was just inability to try really strong cases. I think the judge said that, the DOJ did a great job and the other parties did a great job. I think what you kind of take from it is the fact that it was a specific case that had specific facts, that the principals evaluated and thought that this was the first vertical case that needed to be challenged in 40 years based on the different facts and, kind of different information available. I don't take too much that is this like the last vertical case that's going to be challenged in another 40 years.
I think the decision in the Court of Appeals case, if you get past the initial headline,
yes,
actually gives those people who have vertical theories of harm that are important to them hope for the future.
Yes, I completely agree. And so it's just a matter of when's the next one, the next right one.
That's right.
And who's going to be there when that case comes along, and what is it going to be? I'd imagine that people are going to think really hard about continuing to bring vertical cases. And the second point is it the end of the world? I mean, you want to win every case, of course, but is it the end of the world that someone tried to bring a vertical case and they lost it? No. And I think most people, including at the division or the FTC, realize that.
Right. Perhaps you could give us some insights, changing the subject slightly, of how the DOJ works both at the staff level and more at the political level with other agencies around the world. I mean, there's close contacts with the European Commission, with the Canadian Authority, and so forth. How does that really work in practice, particularly on big transactions, international transactions? Yeah,
that's a great question. And so I think it's very fluid, and it continues to happen more and more. And, I think in terms of you hit it right on the head in terms of this is where it happens the most, is these big international transactions where there could be filings in 10 to 12 plus jurisdictions and where there's potential substantive overlap in many of them as well. So I think the key constant is that you're going to see increasing or continued increasing interaction between the trial attorney or the staff attorney level and their counterparts in whatever jurisdiction it might be, or jurisdictions, and you're going to see it at the section management level and even at the civil and criminal operations level. And that's kind of the way I look at it is it's just part of the practice, and DOJ and FTC and other jurisdictions are used to speaking with their counterparts. They do it well. It's a necessary and important factor of global merger transactions now, and that will only continue. In terms of how it's looked at as on the level of the principal, either in the EU or the US or the other competition authorities, I would think it depends on who that person is and how they like to evaluate and do things. Yeah. Right. So I think that information that comes from the staff, that comes from section management, is going to be funneled up just like any other piece of important information will. And that's going to eventually go into the ultimate decision maker, whether it's the AAG or the principal DAG or their counterpart in the EU, to evaluate it. So I think that whether they're talking or not, it's a matter of it's going to find its way up because it's an important data point. Whether there's synergy, whether the transaction has synergies between the US and the EU or Brazil or not. And so that just goes into the decision-making factor. And, it's the stats on it. I think if you look at some of these larger transactions, I know the DOJ has talked about it. The Director of Civil Operations has talked about how often some of these conversations and information exchange and different collaboration is happening.
I think I've heard from various different people on some of the bigger cases that the case teams, for example, in Washington and in Brussels are speaking to each other almost on a weekly basis.
Yes.
During the hot phase of the case.
Yes,
and then
absolutely.
you also see, the agencies coordinating their timing on decisions, and when you perhaps need a global remedy, then there's a lot more goes into that as well.
Absolutely. And I think, it's a great point. I agree completely. And I think there's significant discussion going back and forth on some weekly or even daily basis, depending on the hot periods. And there's also that happening to figure out whether there is something globally that needs to be done, or frankly, something more specifically in different jurisdictions. So it's something, but I think people probably realize that it's something that's been happening for a while and just continues. I think will continue to happen as big merger transactions.
And I think those
continue.
contacts are becoming more intense and between more agencies.
Absolutely. Yeah.
And that's not going to change. That's only going to become more so.
Right. Particularly as there's more and more jurisdictions, more and more merger control areas where folks are looking at transactions and getting more resources. And, it's truly a global, people call it, I guess, merger control for a reason.
Yeah, that's right.
Yeah.
So one last question to finish up.
Yeah.
You're now in private practice, and I would imagine the attraction of coming to you for a lot of clients is that you have this DOJ background.
Yeah.
What one or two things which you try to explain to clients to help them understand the process?
Yeah.
And ultimately smooth the way for their transaction or their case, whatever it might be.
It's a great question, and something I think that the key word that I think I take from that is actually the process, and kind of knowing and seeing the process from, both being at the trial attorney level and being on teams that are investigating specific pieces of the transaction, and then to the chief of staff level to seeing how that process works too. So I think that the key is helping with, the operational component or how the process works, and it's never one process is the same, but I think there's a lot of things in terms of understanding why the DOJ or FTC is requesting certain information, how you can push back in terms of saying, this is the type of information we can provide, this is the type of information we can't provide, and establishing that open dialogue so that you can make things as efficiently as possible, because until they sue you, for the most part, then
Yes.
the relationship should be, in my opinion, should be as collaborative as possible, because you're trying to come to a specific, you're trying to convince folks that there's no anti-competitive harm in the transaction, and they're trying to come to the same place. So, it's interesting that, someone told me when I was at the DOJ one time, and I was dealing with a party, and both as a young attorney, and I was dealing with another attorney from private practice, and both of the more senior attorneys came and said, I think you guys need to put each other's shoes on for the next day and swap shoes. And so I think that is not necessary in terms of, you don't have to have private practice and DOJ experience, FTC and DOJ experience, but I think what it shows is throughout my career is that there's two sides to everything, and in some areas it's important for DOJ or FTC to understand that as much as we want to provide the data, it's really hard to provide the data. Or there's some areas that, you have to understand that DOJ and FTC or anywhere else is just asking for this as a reason. And so I think that kind of mindset helps throughout the process, and knowing where to, push back, or knowing where to come to some kind of agreement in terms of, we can provide this and this is why. And then, if things progress how you'd like, great. If they don't, then, you take maybe a different tact in terms of, because you're in litigation.
Yeah.
And it's really interesting. I mean, as you can tell, I really enjoy the process of antitrust, and have felt very fortunate to, maybe I'm an outlier, fortunate to represent clients in front of the agencies, and that's a big part of my practice, and very fortunate to have been at the DOJ at these different levels and just see how it works. So. But I'm probably a gigantic antitrust nerd, and I
think there's a few of them about in Washington this week.
Yeah, that's right. That's the problem, So.
Well, it's been great talking to you, Creighton.
Yeah.
And wishing you all the best for the rest of your brilliant career.
Thank you, and likewise, really appreciate it.
Thank you.
Thank you.